Just a few housekeeping items. We're going to be recording today's webinar. If folks have something that they would rather not have recorded or available online, that's not a problem. Just please let us know that after the meeting happens so that we can edit you out. We want to make sure that you're able to ask as honest and of candid questions as possible for yourselves and for your allies in your community. So just please know that. Please mute yourself if you're not talking. There will be a chat pod, there already is. So if there are any issues, please raise those there. There will also be a full Q&A session at the end. So even if you have a burning question, we will get to it. And if it's not a question that we get to during the bounds of our time together, we're happy to find some time to connect and talk about that whenever works for you. So who are we? The folks talking on this call today, we're all part of the movement for housing justice and for racial justice. We all occupy different roles and we work in different parts of the state. As I said, my name is Henry Shah. I work at the Shriver Center on Poverty Law. We are a racial and economic justice organization, and we work throughout Illinois and throughout the country to equip folks to fight for racial and economic justice wherever they live. We also will be hearing today from Willette Benford, who is a social justice advocate. She is a directly impacted woman living in the Chicago area. And we will be excited that she'll ground us very shortly in the meaning of lived experience in this fight. We also have David Heinze joining us from Cabrini Green Legal Aid. David is a lawyer who is on the ground every day fighting with and for his clients so that they can get the records relief that they need. So we're very excited to all be here with you, and we're also excited to welcome you into this space. So just to start with some quick thank yous, first to the people inside. We have a lot of family, we have a lot of clients, we have a lot of allies who are inside prisons and jails right now, which is not easy. During COVID, it is even more difficult. So thank you for persisting, and we look forward to welcoming you home. Thanks to you all too for learning more today, for connecting with us and for connecting with each other. Thank you to our funders who are making this work possible, the Chicago Community Trust, Open Society Foundations, and the Butler Family Foundation. And thank you to David and Willette for preparing to share your expertise today. We have three primary goals today for our session. The first one is that we want to understand a little bit more about housing protections for people with arrest and conviction records. The second is that we want to build awareness of different resources and networks that support returning citizens throughout Illinois. And the last thing is that we want to put this knowledge into action. We want that you can go and hit the ground running and empower yourselves, empower your communities, empower your clients who have records to access housing. One very important disclaimer before I say anything else is that nothing in this presentation is legal advice. There are a lot of attorneys on this call. There are a lot of attorneys in our coalitions and in Illinois more broadly who will be able to take on clients and offer you legal advice. This is not one of those times. And if you need a referral, the chat pod is open. You can directly message people through Zoom, I believe, and we're happy to brainstorm with you as you need. Without any further ado, I'd like to turn it over to Willette Benford, who's going to be talking to us today about creating a movement led by and for directly impacted people, about being a leader both inside prisons and jails, but also outside in the community. So Willette, I will let you take it away. Willette, you can go for it.
Hello, everyone. My name is Willette, and I'm a leader in this movement for returning citizens. And I just have a couple of things to say, a little something that I wrote, and I hope that it just kind of enlightens you on things concerning returning citizens. On April 25th, 2019, it marked the passing of the Just Housing Amendment. The amendment passed with an overwhelming vote of 15-2. The Cook County Board of Commissioners had spoken. This now meant that in Cook County, it was illegal for someone to be denied housing based off their past convictions alone. Landlords now had to consider things like how long ago was the conviction, are they gainfully employed, Are they able to pay their rent? And are there signs of true rehabilitation? And does the individual pose a threat to the community and society now? With 28,000 men and women leaving IDOC each year and thousands leaving local and county jails, it's hard to imagine building a successful, productive life without access to stable employment and safe housing. Yet, we are expected to do just that. The many barriers that accessing housing that individuals with past convictions face are a result of long-standing institutional and systemic racism and economic segregation within our nation. The Just Housing Amendment was a huge victory in the ongoing fight to bring justice and equality to policies and systems that have ignored entire classes of people based on background, color, economic status, education, and many other stereotypes that will take much more than an hour to address. When these policies and systems go unchallenged, they become deeply entrenched in the fabric of our nation and require true warfare from those enlisted in the fight to uproot them. Those chosen to challenge the institutional and systemic racism are met with brutal opposition. Nevertheless, we do not quit, knowing that whenever a small degree of it is tolerated, the individual, community, city, state, and nation, where it is tolerated, becomes contaminated. Speaking up on behalf of returning citizens is not only the right thing to do as an individual, it is the humane thing to do as a nation. I am a returning citizen with lived experience. I know firsthand what it feels like to be homeless and to live in a homeless shelter, and then have those that have allowed you to be a resident at their transitional house to tell you that you are ineligible for housing based on a decades-old background. I did everything expected of me and was still told no when it came to housing. That no came from an ally that had suddenly become an enemy. That no catapulted me into the fight for justice for those that would so follow in my footsteps. Yes, I became a leader and a part of this work because of circumstances and not by choice, just like so many others before me. Knowing that this class of citizens are often an overlooked class because of stigma, preconceived judgment, and fear. This type of fear is formed by false narratives and exacerbated by many that have their own hidden agenda. Knowing that much of what people believe is derived from not being fully informed or partially informed or completely misinformed, my goal is to continue to be a part of a cause that will constantly seek to educate and seize any opportunity for a teaching moment, attempting to bring clarity to those who are unaware or have not taken the time to think it through and realize that returning citizens are human beings just like themselves, all the while forming new alliances with them so we can learn valuable lessons from one another. No longer allowing institutional and systemic racism, classism, and sexism to declare someone unfit for housing, employment, health care, or any other place in our society, especially when they have paid their debt to society. Sometimes the debt not owed, yet in the event it was owed, they have paid it, and they are no less deserving of a second chance than anyone else. We do not want an invisible seat at the table. We do not want it just to say we have it. No, we want it so we can be heard and make a difference. Our input matters. Who better to inform you or give you knowledge about a subject than the experts on it? Shriver Center on Poverty Law, along with many other organizations, has given me and others that opportunity. I now know what it feels like to have keys to my own front door. It's one word, liberating. And if I'm not mistaken, those words, liberty, freedom, and justice, are in our Constitution and describe the life to be lived not by a chosen few, but for all. Because of that feeling of liberty, I will not cease to speak up, and neither will others until it becomes absurd and absolutely unheard of to deny anyone one of the basic necessities of life, and that is a right to have a place to call home. Thank you.
No, thank you, Willette. Thank you for grounding us in those words. I think we all aspire to the level of clarity and of expertise that you have. So thank you so much for joining us.
You're very welcome, Henry, anytime.
Yeah. So thank you, Willette. Thanks once more. We're going to talk today about the movement that Willette talked about to stand with and for people with records. And the way we're going to do that is we're going to work through a few different areas of the law. We're going to be talking about a few different types of legal protection. And those legal protections really depend on a few different items. The first thing is area. Where do you live? Where are you looking for housing? There are protections at a federal level that cover all people in the United States. There are protections at a state level that cover all people in our state of Illinois. And there are a lot of protections that really depend on town to town, place to place throughout our great state. Looking for housing in Cook County is very different from looking for housing downstate in Cairo, Illinois. It also depends on the type of record that we're talking about. We could be talking about arrests, we could be talking about conviction records, we could be talking about participation in a drug treatment program that was ordered by a court. There's a wide variety of ways to have your information connected to the criminal legal system, and it's important that we be precise when we think about that. The next item, and this is especially important when we think about housing, is that it really depends on timing. When is the issue with your record happening? Before the application process even starts, as you seek out housing and you might see a blanket ban or discriminatory advertising on Craigslist. It could happen before the application starts as you look for resources for people coming home, from service providers to special types of housing like the Chicago Housing Authority pilot. And then as you move into the application process, it'll have another impact. There are restrictions on how and when records can be used, for what purpose, depending on what type of housing exactly you're seeking. And even after you move in, after the application process is over, there is also a potential impact of having a record. Suspected or confirmed criminal activity that happens after you get into housing could lead to the end of occupancy. It could lead to eviction. It could really depend. And it could happen after the application process because it could happen through enforcement. You could go to a court or another government body to make sure that your rights are respected as a person in the state of Illinois. And the last thing, and this is the way that we'll be dividing up the webinar today for clarity's sake, is that it also depends on the issue. Why is the record coming into play? And does it interact with any other event in our lives? It could be disability, it could be domestic violence, it could be a need to live in public or subsidized housing. It could be a need to move from one county to another. There are lots of different things that could come into play here. And so accordingly, we'll be covering four major areas, major subject matter areas. The first one is protections for all people with records. Try to be as general here as possible. The next is protections for people in public and subsidized housing, because there are some very specific rules and rules that vary quite considerably from state to state. The next are protections that are related to domestic violence. Again, this is something that Illinois has specific laws for. And the last thing is protections related to disability status, not just disabilities that might be more visible, but also disabilities related to substance use and related to mental health. The first thing we'll be talking about today is protections for all people with records. The overarching protections here are federal protections. So these are protections that exist throughout the United States. One important framing item is that the federal government recognizes that the use of criminal history affects Black, Latino, and Native people disproportionately. The federal government under the Obama administration recognized that a criminal record is not a piece of information that exists inside of a void. Criminal records and policing and the criminal legal system have an intimate effect on people of color because of decades and centuries of housing segregation and of over-policing in communities of color. So the Department of Housing and Urban Development, or HUD, and the federal government recognize that. And they also set out some guidelines on how records should be used to help reduce the discriminatory role of criminal records in housing. The first thing is that arrests are not a reliable way to tell if someone will be a good or a bad tenant. That is to say that in our legal system, we have the principle of innocent until proven guilty. And if you've been arrested of something, it does not mean that you are guilty of that conduct. It does not mean that you have been shown in a court of law beyond a reasonable doubt to have engaged in a certain piece of conduct that would lead to a specific piece of criminal record. And so what that means is that using arrest record is not a reasonable inference to tell if someone will be a good tenant or not. The next thing is that conviction should be evaluated on a case-by-case basis. This most immediately translates to the idea that there should be no blanket bans. These are very popular, unfortunately, online on things like Craigslist or Zillow, where landlords might say things like no felons or no criminal history or no background in the last 3 years. The federal government has been very clear. And what they've said is that blanket bans violate the idea that every single record has a context and every single record is based on an individual story. A criminal record is a reflection of something that happened a given amount of time ago. It happened with a specific police department in a specific place, with a specific piece of conduct, with specific facts, and with specific individuals involved. And housing is such an important thing, and the risk of racial discrimination is so high that folks really need to look at records inside of their individual context. A conviction for drug possession, if someone is suffering from substance use disorder, is very different than a conviction from drug possession for other reasons. The next level of protection are Illinois protections for all people. Illinois has been a leader in recognizing the role, the harmful impact of criminal records on communities of color, and recently passed an act called the Housing as a Human Right Act. It is now a state civil rights violation to deny housing for specific types of criminal records. These records include any arrests that don't lead to a finding of guilt, juvenile records, so records that happen before folks are 18, any record that has been ordered expunged, sealed, or impounded. And David from Cabrini Green will be talking about that very shortly. Illinois has also recently passed a really massive piece of cannabis legalization legislation. We're going to be talking about this a little bit more later when David starts talking. But what we can say is that many arrest and conviction records might no longer be part of a records check at all. Because if they're expunged or sealed, that means that they're off limits in ways to housing providers that they weren't beforehand. And the big caveat with any Illinois protections or local protections, and we'll continue talking about this throughout, is that federal regulations and laws take precedent over Illinois protections, and Illinois protections, for the most part, take precedence over local protections. So if something applies at the federal level, for example, we'll talk about this with subsidized housing, if there's a rule that subsidized housing providers have to provide a denial in any circumstance, even if it's based on one of the records listed here in the Illinois Housing as a Human Rights Act, they have to deny. The Illinois law does not take precedence over that. The next item are local protections for all people with records. Willette's leadership was very visible and pivotal to passing what's called the Just Housing Amendment in Cook County, Illinois. This is one of the broadest fair chance housing ordinances in the entire country to lift up people with records, especially people of color. And it's also in the largest jurisdiction so far throughout the country. So it's very exciting, and it has far-reaching consequences. The first one is that there's no use of convictions more than 3 years old of any type, unless it's mandated by federal and state law. So for example, and we'll talk about this with subsidized and federally subsidized housing, if the federal government has passed a law saying that something, a conviction more than 3 years old needs to be used, then that still needs to be used. But other than that, any type of conviction, whether it's for loitering or whether it's for first-degree murder, any type of conviction more than 3 years old cannot enter into the equation when folks are evaluating housing. The next thing is that there is a total ban, and this you'll see parallels what happened statewide in Illinois. There's no use of any arrests, juvenile records, participation in deferral or diversion programs, or expunged and sealed records. No use at all. It could happen last week, it could happen 35 years ago, but there's no use. And the last thing is that if providers decide that they want to use covered criminal history, and again, that's only convictions where it's mandated by federal or state law, or it's a conviction less than 3 years old. If they want to use a conviction less than 3 years old, they have to follow a transparent, individualized process. They have to do things like notify the applicant before they run a criminal history check. They have to do things like do all of the application process except for the background check, make sure that someone meets the income requirements. If someone has, 9 pets, 3 iguanas and 6 dogs, but there's a ban on lizards in the building, they need to make sure that that person can actually get into the housing before they actually run a background check as a way to reduce discrimination. And they also need to provide folks with a copy of their screening criteria and a copy of the background check that they're going to run. This is important because there are a lot of duplicates. There's a lot of misinformation in the very unwieldy tenant screening records industry. For example, if your name is John Smith and you're looking for housing in Peoria County, there are several thousand arrest and conviction records in the county database related to John Smith alone. Even if you're John R. Smith, there are hundreds of John R. Smiths in Peoria County. And the risk of duplicates and of misinformation is very high. So that process needs to be transparent. Again, this is only in Cook County. In Champaign and Urbana, those twin cities in the center of our lovely state, there are local laws. In Champaign, providers can only screen for specific types of conviction that happened in the last 5 years. Those convictions are specific, and we can go into more detail about that if folks want, but it's about the use of force or violence, and it's convictions related to drug use in the last 5 years. And that 5-year rule and the 3-year rule is called a look back period. That's basically how far back into the past can a provider look. In Urbana, there's a law that says that you can't discriminate on the basis of an arrest or conviction record. What does that mean? It's a little less clear, but it's going back to that idea that the Obama administration had at the federal level that's still in effect today. But it's saying that arrest and conviction records happen within a specific context. And you need to be able to fully consider the impact of that arrest or conviction record in light of all of the circumstances. And again, I'm going to underline this as we go along because it's very important. Local laws always have exceptions for federal or state requirements. If people are on lifelong sex offender registries in Cook County, then landlords still are able to screen for that. If people are banned from public or subsidized housing due to federal law, the Cook County or the Urbana or the Champaign legislation will not take precedent over that. So that's something to still be aware of. What we'll talk about next is protections in public and subsidized housing. Public and subsidized housing, it covers a lot of ground. We're talking about any program with federal dollars. That could be, what some folks call a housing project. That could be a single site building. That could be a housing choice voucher program or Section 8. It could be a building like the building that I live in, which is a federally subsidized but mixed income building. It applies to a lot of different things. And what kind of housing is available? It's not just folks moving into a new housing unit. It's also people being added to existing leases. This is very important as we face down the COVID pandemic, as people are coming out of prisons or jails at hopefully faster rates than they have been before, and are really pressed to find housing and often find it first on the couch or in the spare room of a loved one. People can be added onto existing leases. The federal government has made it slightly easier during COVID by giving waivers on certain admissions requirements. And people can, with greater ease than ever before, join their loved ones in existing leases. Two things that we can't underline enough. Unit availability varies a lot throughout our state. The waiting list in Chicago or in Cook County is very, very long. And then there are housing authorities downstate that have several hundred units available at any one time. So there is quite a lot of range and variety about where you can get housed in public or subsidized housing. There's also a huge range throughout Illinois on the discretion, the types of individual judgments that local housing authorities can use when they use arrest and conviction records. That means that looking for housing in Winnebago County is very different, around Rockford is very, very different than looking for housing in St. Clair County around East St. Louis and Metro East. And it's important to be aware of your different options throughout the state if you have that mobility available to you. The federal government, this is something around which there's a lot of information floating out there. The federal government requires denial in only very specific circumstances. They give wide authority to local housing authorities to deny about a lot of different things, but there are only very specific circumstances where a local housing authority must deny an individual. One of those things is if someone has been convicted of manufacturing methamphetamine on federally assisted property. As you can tell, very specific. There are not a whole lot of folks in Illinois or anywhere else throughout the country where local housing authorities must deny people on the basis of that conviction. The other one is a little bit broader. People who are required to register with the state because of past sex offenses for the rest of their lives, they are also, local housing authorities are required to deny them. We can pass things like the Just Housing Amendment. Champaign and Urbana can pass their local laws. Their local housing authorities could really want to let these folks live in their housing, but federal law prevents it. So that is a mandatory denial. The other mandatory denial is related to past alleged drug-related activity. So if the applicant has been evicted from federally subsidized housing in the past 3 years for drug-related activity and hasn't shown that the circumstances leading to the eviction don't exist anymore, the local housing authority must deny. What might those circumstances be? That could be to show that those circumstances don't exist anymore. You or your loved one could have entered a treatment program. You could have a letter of recommendation talking about how you've turned your life around or how things have changed since that eviction happened. But you will have to prove that. And if the local housing authority denies you haven't, then they are required by the federal government to deny you housing. As we said, local admission policies vary very widely throughout Illinois. There are circumstances where the federal government requires housing authorities to deny people, but local housing authorities have a lot of latitude. And we at the Shriver Center have been piecing together different admissions policies, and we're happy to talk about folks not on this webinar today about different policies throughout the state, so let us know. Some housing authorities are very restrictive. Some have much looser policies. And these policies are also in flux during COVID. HUD, that federal agency responsible for federally subsidized housing, has been issuing waivers that allow housing authorities to change their rules and to give people more of a chance to get housing as they so desperately need it. The biggest principle is that everyone should get a chance to explain their record. Going back all the way to the start of the presentation, the federal government has made clear that no piece of arrest or conviction history exists in a vacuum. That people, when they're looking for housing, should not just be, they shouldn't just run the check and then deny them immediately, even if the local housing authority has a very restrictive admission policy. To give a more restrictive example of how a housing authority uses their discretion, in Springfield, the housing authority folks down there have decided that to be qualified for housing, you can't have a misdemeanor on your record in the past 3 years, and you can't have any felony activity in the last 10 years. So this policy, as you might be able to tell, has got a little bit of an issue with it. It looks a lot like a blanket ban, but you should still get a chance to explain your record, even if it has a very daunting sounding standard for you. A less restrictive example is in Cook County, where I'm at. They don't use anything, including convictions more than 3 years old, unless they are required by the federal government to do so. Again, they have the discretion to make different rules, or at least they did before the Just Housing Amendment came into effect, but they have decided affirmatively because they've seen that getting housing is important, and that getting housing is actually a public safety measure, and that improves outcomes for folks, that not using anything more than 3 years old is a good policy decision, and they've used their discretion to do that. The next thing we'll talk about are protections related to domestic violence. To frame the conversation, we're not just talking about women. The laws we're talking about here are talking about all survivors of domestic violence, sexual assault, dating violence, and stalking. Gender is not entering into the picture from the perspective of the law. And we're also not talking only about physical violence. We're talking about patterns of power and control. We can go more into this, and we'll have some case studies that give examples of this. But sometimes substance use and substance dependency is related to domestic violence situations. And that can also be grounds on which you can think about your rights. The biggest piece of legislation is what we call VAWA, the Violence Against Women Act. And this is a federal law. It protects a lot of people. It protects victims of domestic violence, victims of sexual assault, dating violence, and stalking who live in federally subsidized housing. And it sets forward pretty clear rules that protect those folks. People cannot be denied admission, be evicted, or have their assistance terminated because of the violence committed against them. People need to, when they enter federally subsidized housing, they need to get a notice of their housing rights under VAWA. I did this about 2 weeks ago when I moved into my new place, and it's a piece of paper you have to sign that says that you have the rights, these rights under VAWA. They can also request that an abuser be removed from the lease in the housing where applicable and keep their own housing. So if there needs to be a split or a breakup in the lease so that the survivor can stay put, and that the abuser, due to an order of protection or some other reason, needs to be at a safe distance from the survivor and their loved ones, VAWA provides the room to do that. VAWA also says that survivors have a right to confidentiality, that if you've experienced sexual assault or dating violence or stalking or domestic violence, you have a right to not have that information shared. You can also seek an emergency transfer to other federally subsidized housing in order to be safe. So as I said, Illinois has a lot of federally subsidized housing throughout the state. We have a big state. We luckily have an ambitious state where there's a lot of public housing. And if people need to get out of where they're living and use VAWA to that Violence Against Women Act to get somewhere else, VAWA provides room to do that. Illinois also has gone a step further, which is really great. And they have passed something called the Safe Homes Act. So this does not replace the Violence Against Women Act, VAWA, but it supplements it. What it says is that tenants who are experiencing domestic violence, sexual assault, dating violence, or stalking, they can ask their landlords for an emergency lock change. So if they need to have that physical protection, they can, or they can end their leases early due to a credible imminent threat of violence against them at their home. So if people need to get out of town or they need to change their housing, the Illinois Safe Homes Act provides that space for them. Sexual assault victims can also seek a lock change or end their lease, even if there's no ongoing threat. If that incident happened, if they experienced a sexual assault at their home, at their federally subsidized place of residence, they can seek those protections as they need, even if they're not able to prove that there's an ongoing threat. This is an area where the Shriver Center has done a lot of advocacy, and we're happy to give you sample documents as you may need. The last specific subject area we'll go over before I turn things over to David is disability status. The most useful phrase throughout this theme is reasonable accommodation. What does reasonable accommodation mean? Reasonable accommodation means that people with disabilities can request this. It means that you have the right to have things changed or adapted to fit your disability status. We're talking about all different types of disability status. And reasonable accommodation notably includes people who are recovering from addiction and people who have successfully completed or are undergoing substance abuse treatment. So this relates to a few of the other protections we talked about today in federally subsidized housing and also in protections for people with all different types of record. Reasonable accommodation includes people with substance use dependency. It does not include current users of illegal substances. It does not include people who can be shown to be a direct threat to the health and safety of others. And it also does not include people whose tendency would result in substantial physical damage to the property of others. So there are those three important, I wouldn't even call them exceptions or carve-outs, but there are those three areas where reasonable accommodation is not quite as strong of a protection. And with that, I'm going to turn it over to David Heinze to talk about records relief, to talk about sealing and expungement here in Illinois. and he's got slides of his own that he will walk us through. So David, please feel free to go ahead when you're ready.
Okay, thank you, Henry. And let me echo what you said about Willette's remarks. I'd like to thank her for those powerful remarks as well. So I'll get right into it since my time's limited, but I'll be here for questions at the end. So if we could go to the what is sealing and expungement slide. It's the second slide. So Illinois has passed laws which allow you to petition the court to remove all records of an arrest or criminal case from public view. And there's two types of relief you can ask for depending on the disposition of each case. So expungement is available for arrests and criminal cases that did not result in a conviction. And there are some limited exceptions to that, depending on the charge. So if your petition for expungement is granted, the arresting agencies will destroy the records and the courts will impound them. And no background check of any kind will reveal those records. The second form of relief is called sealing. So that's available for arrests in cases that resulted in a conviction. And there are some limited exceptions for that as well. If we could go to the next slide, Henry. This is just a brief overview of what the filing process looks like in Illinois. So the first step is a client or petitioner would obtain their documents, their Illinois State Police report, or if you're in Cook County, your Chicago rap sheet, which will allow you to get a full sense of the records history. Then the petition is filed. There's a 60-day notice period where the state has a chance to object to the petitions. If the state has a wide range of things they look for when determining whether to object, the seriousness of the case, the extensiveness of the background, but it's possible that no objection will be filed and it will go through automatically, more or less. So if we could go to the next slide. This is just a list of the ineligible convictions in Illinois. So I'm not going to go through them all, but you see that there's domestic battery, sexual offenses, violations of the Humane Care for Animals Act, and DUI. So Illinois actually has really liberal criminal records relief laws, which we should be thankful for, because that's not the case in many other states. So let's skip ahead to, or wait, let's keep it on that slide. So the most important thing I can talk about today for people who are being released from IDOC is the 3-year waiting period from the date of your last conviction. Normally in Illinois, you're required to wait 3 years to file from the date of your last conviction. So that's a period starting with the date of your sentence, which is usually when you pled guilty or were found guilty, and that runs to whenever you get out of IDOC or whenever you get off of mandatory supervised release. However, if you'll go to the next slide, you'll see that there's an exception to that 3-year waiting period, where if you earn a diploma, GED, college degree, vocational certificate, or career certificate while you are serving the sentence, you can waive out of that period and file for sealing and expungement right away. So that means from the date of your sentence to the date of completion of your sentence, if you earn the degree in that time, you can waive the waiting period. And Illinois has the courts that take a pretty liberal approach to what qualifies as a certificate that they're willing to accept. So even as an example of one of the easier ones to obtain would be something like a ServSafe certificate, which is just a food safety course that some restaurants require employees to take. So let's go to the next slide, Henry. This should be what if a person doesn't qualify. There are alternative forms of relief. I'm not going to get into them all because my time is limited, but even if you have an ineligible conviction, you may be able to obtain some relief through those measures, and I'll be happy to discuss that more in the Q&A. So if we could go to the next slide. Sealing and expungement, the big areas that we think about when we think about why it's important is housing and employment. Henry's discussed how important it is in housing law, and it's also really important in employment. It's a civil rights violation to use an arrest record against an applicant for a job. An arrest record does include sealed or expunged records. So it's illegal in Illinois to use any sealed or expunged record to make an adverse employment decision, which includes rejecting somebody who's applied for a job. And there's just a limited exception to that. Some employers are authorized by Illinois law to use sealed felony convictions, and in some cases required to use sealed felony convictions when determining whether to accept an applicant to a job. But those employers are limited, and they include governmental agencies, hospitals, the CTA, employers like that, or police departments as well. So let's just go to the next slide, and that's titled, "Who Can Help Me Seal and Expunge My Criminal Records?" So the first thing to note is a lot of you are probably returning to Cook County, and the fastest and easiest way to get free legal assistance is the Cabrini Green Legal Aid Help Desk, and that's located on the 10th floor of the Daly Center in downtown Chicago. There's also a help desk at the Markham Criminal Courthouse, which could be more convenient depending on where you live and where your cases were heard, because the petition will have to be filed in the court that the case was heard in. Obviously, the help desk is closed right now, but CGLA set up a virtual help desk where you can go to our website at cgla.net and click on the Get Help tab and apply for records relief, and we'll research, draft, consult, and get everything ready for filing. So when the court does open up, you're ready for filing. I see that my time's running out, but let me just say that if you live in northern or central Illinois, Prairie State is available. If you live in central or southern Illinois, Land of Lincoln Legal Aid is available. So just in the few seconds that remain, could we go to the final slide? What are some things I should start doing now? So it's a personal choice whether you want to go out into public and get your ISP report or your rap sheet. But if you do, you can get your ISP report at any police department, and for information on how to get your Chicago rap sheet, you can just Google how do I get my Chicago rap sheet, and the instructions are pretty clear. And the most important thing I can say today is if you're returning home from IDOC and you're on mandatory supervised release and you haven't obtained a degree or certificate of some kind while you were in IDOC, you should seek out something in your community that you can attend and use that as a way to get out of the 3-year waiting period in Illinois to file. So with that, thank you, Henry, and I'll turn it back over to you.
No, thank you, David, for that clarity. Can I ask you one clarifying question just to pin down the difference between sealing and expungement? So someone once explained to me that sealing was like taking the piece of paper that your record's on and putting it in a safe and putting that safe in the courthouse, and saying that the courthouse can only open up that safe if there's a reason to do so, a court order to do so. And then they said that expungement was like taking that safe out of the courthouse and throwing it at the bottom of the ocean, and dissolving it in acid or something, making sure that it doesn't exist anymore. Is that that might be a crummy metaphor, but is that accurate? That sealing is the record's not totally gone, but it's court protected, and expungement means that it's totally gone.
That's a good question. The most important thing to know is that both expungement and sealing, although expungement provides greater relief, they're both really, really useful to petitioners. So one isn't necessarily a crummy form and the other is a good one. But so if you get a record expunged, which is only non-convictions, the arresting agencies will destroy the records and the court will impound them. So the court puts them in a safe, so to speak, and the arresting agencies destroy them. That means that if you get pulled over during a traffic stop, the cops won't be able to see that. But if you do come back to court, say that you got a special drug program sentence, which allowed you to expunge your records at the end, and then say you violate again later, the court may take a look at that. And obviously, when we think about an agency like the FBI, technically they're supposed to comply with these laws, and there's some indication that they do, but you just can't be sure that a federal agency like that is going to really eliminate the records. And for sealing, what happens is the records are impounded by the court, so they're put in that safe and they're hidden from public view, but law enforcement agencies will be able to retain them. So if you come up on another charge for anything, they'll be able to see your entire record. But law enforcement agencies and the courts don't disseminate that information to anyone without legal authority to access it. And the only people with legal authority to access it are those employers that are expressly permitted by state statute to consider felony convictions. Does that answer your question?
It does. Thank you for that level of detail. That's a question that we get all the time. So I'm aware that we are getting to the last 10 minutes of our time together. I'm going to make a slight change. We're going to do a single case study, and then I'll open it up to questions. I'm happy to stay on the Zoom after 3 p.m. elapses for as long as folks need to talk about questions and ideas. And David and my colleague Marie-Claire, if they're able to, will do so as well. No pressure to you both. And no pressure to you all if you need to hop off, but you have a burning question and we don't get to it, please feel free to put it in an email, put it in the chat box, and we can figure out a way to follow up with you. So 2 quick things before we open up the floor to you all. The first thing is, where can I go for help to know and enforce my rights better? David gave a great answer to this about the different geographic regions of Illinois. There's a local legal services provider. If you're in the city of Chicago, it's Legal Aid Chicago. But it really depends on where you are. So please give that a Google search or ask around. If you live in Cook County, Cabrini Green Legal Aid, David and his wonderful colleagues can help you expunge and or seal your record, whatever the case may be, if that's possible for you. And your local Fair Housing Initiatives program, what we call FIP, that local provider can also help. So these are places that can do things like a fair housing investigation. They can help you understand the landscape of protections that might be helpful. If you think, or one of your clients thinks that they've been discriminated against, but they're not quite sure how, the folks at the FIPS can be very helpful in connecting whatever happened to some real solutions. And I've provided a link in the PowerPoint, which I'll be circulating after this so that folks can find that FIP where they live. We're going to talk about a very quick case study that brings together a lot of these themes, and then I'll turn it over to you for questions. So this case study is about YUNA. YUNA is a former county employee and a youth advocate. YUNA is also a survivor of domestic violence. The domestic violence lasted over a period of 5 years, and one particularly severe episode resulted in hospitalization. YUNA's abuser was dependent on heroin and prescription opioids and often pressured YUNA to use drugs. After her discharge, she struggled with depression, PTSD, and drug dependency, which led to her arrest and eventual plea to possession of prescription painkillers in 2017. With a lot of support, she eventually left her abuser and lived in a shelter for a period of time. She applied for an apartment, but she was denied because of the landlord's zero-tolerance policy for drug-related convictions. So the reason we're going to talk just about this case study is because it brings up a lot of things that are applicable here. Let's imagine that YUNA is looking for housing in Cook County. The plea to possession of prescription painkillers happened in 2017. If it happened before, June 1st, 2017 or before, that's now above that 3-year look-back period. That conviction, that piece of criminal record, should not enter into the conversation at all unless someone is federally mandated to do so. The next thing I'll say is that the landlord has a zero tolerance policy. A zero tolerance policy means if the landlord says, hey, if you've got a drug conviction, if you've got a felony conviction, you can't live in my building. That violates the federal government's idea that every piece of criminal history should be examined in light of its circumstances. And that also, let's think about if YUNA was living in Cook County, the idea and the legal process for evaluating YUNA's record in light of all the circumstances. And then going to other things like the Violence Against Women Act, VAWA, going to the reasonable accommodation and disability protections. YUNA suffered from some serious mental health issues. YUNA's conviction happened in circumstances where she had a loss of power and control, where her substance use was tied into serious issues of violence. And you as a person who might have experienced similar things, you as a client advocate, you as a loved one, you can advocate for people like YUNA on that basis, because YUNA has taken some serious steps to change her situation. So we just wanted to give that case study to show that the law can be messy. Real life is messier. Real life is a little more complicated, but that there are quite a lot of protections available to people like YUNA and many others throughout our state. So without that, I see we have 5 minutes left. I'd like to open the floor for questions. To keep things rolling, I'd love if you can use the chat box. If you're calling in on the phone, what you can do is unmute yourselves and then ask your question that way. But chat box is best if that's possible and you're on a computer. And we already have one question. The question is, can you further explain how a person could cause property damage to others? So I believe this was related to the exception to reasonable accommodation. I can try to give you a very specific example that actually came up during our Just Housing Amendment work. Let's say that someone has suffered from a mental illness that leads to a manic episode, and that person was convicted in the last 3 years of a crime related to property damage. Let's say this person has broken their neighbor's mailbox and they get arrested for vandalism or something like that and convicted of vandalism. The landlord might say, hey, look, I'd love to let you into my property, but it looks like you have a history of violent crime. And because we'll imagine that this person's living in Cook County, that person can say, I was convicted of that. That was me. That is a piece of my background. That episode also happened when I was experiencing a mental health crisis. That's not who I am right now. That's not who I am today. That's not who I'll be as a tenant. So there's that. There's the idea that the circumstances have fundamentally changed. I hope that answers the question. That there could be pieces of criminal history that are directly related to that could lead to very specific types of conviction, right? Like as with the YUNA example, the plea to possession of prescription painkillers, she wasn't running an international drug trafficking ring. She was a survivor of an abusive relationship, and her drug use was related to that relationship. Anything else? And as I said, if folks are more comfortable sharing verbally, if they're on the phone, please feel free to do that instead of using the chat box. Anything else? I'm not seeing anything rolling in here. I'll give folks a little bit more time before concluding. And that also includes questions like if I went over something too fast or unclearly, please let me know and we can reverse a little bit. Alrighty. Well, if you have any questions that flow through your mind as I close us out, please don't hesitate to share. I'm sure we'll all benefit. A few housekeeping items to wrap up. Thank you for your attention. We live in a crazy world. And we live in difficult times, and today is one of those days, I think, for a lot of us, and it's one of those weeks for a lot of us. So thank you for being here and for doing this work. We will be following up with a few items. We'll be following up with a copy of this PowerPoint presentation. So if you need to look through things again, or you need to share it with your colleagues, then you might come back to us with questions. That's totally okay, and we encourage you to do that to keep the conversation going. We'll also be sharing a fact sheet that was just reviewed by the governor's office and the lieutenant governor's office on rights for returning citizens coming out of Illinois prisons right now for housing, but also for other public benefits, including Medicare and Medicaid. So we're happy to share that resource with all of you today because we confirmed that and finalized that this morning. And if you have any questions about that, or if you find it really useful, we can brainstorm about ways to put it into action. And also, I mentioned a few resources that might be useful that we do at the Shriver Center. There's information on the Violence Against Women Act, and we have some great experts on VAWA in-house. So if that's an area of advocacy you're interested in, we can follow up about that. We can follow up about passing fair chance housing ordinances like the Cook County Just Housing Amendment that Willette spoke so powerfully about, and in involving directly impacted people and having them as leaders of our work. And all that to say is that there are a lot of ways to keep this conversation going. We're excited that we were able to start it with you all, and we look forward to the future. So thank you so much, and have as safe and as peaceful of an afternoon as you can. Take care, everyone.